Virginia's new record sealing laws. I referred to these as Virginia's most impactful laws that no one knows about. And that's a slight exaggeration, but hopefully we can start to change that. We have some time because the laws don't go into effect until 2025. And I know that it's early this morning, but hopefully you'll indulge me in just a little bit of a history lesson. Prior to these laws being passed, Virginia has always had expungement. And expungement in Virginia is defined as it's only for charges that have been dismissed. So if somebody went to court and they were found not guilty, or somehow the charge was dismissed, then the charge could be expunged, and it essentially disappears. It comes off the person's record. In Virginia, we have about 1.6 million people that have a criminal record, and expungement happens about 4,000 times a year. So there was some discussion in the legislature about reforming expungement, expanding it. And so in 2020, they had the Crime Commission do a study. And what they found is that 41 states allowed misdemeanor convictions to either be sealed or expunged. 36 states allowed felony convictions to be sealed or expunged. And then generally for the misdemeanors, people had to wait 3 to 5 years to have this happen. For the felonies, it was on average 5 to 10 years for that to happen. So in 2021, we had some bipartisan legislation. And yes, even in this day and age, there is bipartisan legislation. And I think it underscores that these laws are actually very popular with the public. And so finally, people are going to have a second chance to become employed and have some advanced certain opportunities. Again, these laws become effective in July 1st of 2025. They were passed in 21. The reason it takes so long is just to upgrade all of the computer systems. There's about a $14 million process that was implemented by the Virginia State Police, another $1 million for the court, over $1 million for the courts. And so what we ended up with in 21 was clearly a compromise, but essentially has a couple of different components. One is there is automatic sealing of some convictions. So there are 7 misdemeanor convictions, primarily trespass, petty larceny, things like that, minor offenses, that if the person goes 7 years without another criminal conviction, that conviction will be automatically sealed. The other component is sealing by petition. The sealing by petition is actually the much larger component. And this sealing by petition applies to all other misdemeanors except for DUIs and domestic assault. It also applies to class 5 and 6 felonies and any felonies that are treated like grand larceny. So here we're talking about grand larceny, embezzlement, credit card fraud. All of those charges, you have to do a petition to the circuit court where the conviction was, and then the judge has to grant that petition, and then your conviction is sealed.
Hey, George,
so,
real quick.
Yes.
George.
Yeah.
Yes. Sorry, we were having some internet issues here. In the very first.
All right, I'm not getting you at all. I don't know if you can hear me.
This is David. I'm on the teleconference and I can hear you.
Yeah, I don't think
Okay,
can you hear me now?
Yeah. Again.
You want to let me know when I can continue?
Let's see if I can do
A hotspot.
a hotspot on my phone.
All right, George, can you hear us now?
I can, yes.
Okay, sorry, we were having some internet issues. Could you go back and just give us a quick overview of what automatic unsealing is? Because
Sure.
the audio cut out at that point. So I'm sorry
Right.
to interrupt, but we
Yeah,
missed that, and I feel that that's very important to cover.
Yeah. So basically with the laws, we ended up with two types of record sealing. We have automatic sealing and then sealing by petition. The automatic sealing applies to 7 misdemeanors. They're the lower level misdemeanors. They're trespass, petty larceny, things along those lines. And if somebody goes 7 years without another criminal conviction, that petty larceny is going to be automatically sealed. The person doesn't have to do anything. The state does it all on its own. The larger portion of what can be sealed is done by petition. Here we're talking about every other misdemeanor conviction except for DUIs and domestic assault. And we're also talking about the lower level felony convictions, so class 5 and 6 felonies, and then things that are treated like grand larceny. So grand larceny, embezzlement, credit card fraud. So that's the category of sealing. With the petition sealing, in the jurisdiction where you had the conviction, you had to do a petition to the circuit court. The judge has to grant that petition. So whether you had an automatic sealing or a petition sealing, what is sealing? Well, the code defines sealing as restricted dissemination. So what that really means is the state police, the courts, the clerk's office can no longer put out that information about the conviction. I tell people, just think about a conviction becoming invisible. With any law, there are exceptions. There's 25 exceptions to the sealing legislation in the code. They are primarily for law enforcement purposes. So what do I see as some of the impacts for employers, employees across the state? Well, the biggest thing is that once a conviction is sealed, it can no longer be reported by the business screening services. And so business screening services are companies like Checker, Validate, these types of companies. So if you're an employer and you do a background check on an employee, use one of these companies. After a conviction is sealed, it is no longer reported by Checker or any of these other business screening services. So the person's background check comes back clean. If you use Checker, then the person has all green. There's no red flags. There's no orange flags. The other thing is that the legislation says that a person who has a conviction that is sealed can deny that conviction on applications. And those are applications for any private employer in the Commonwealth, and then also employment through the state, whether it's state or local employment. Again, of course, there are some exceptions to denying the conviction and where they can be seen. This is if you're applying for a job for law enforcement, or if the Virginia Code specifically says that there has to be a background check to work in that field. So here you would think of things like nursing. Another exception is federal law and national security. These applications and being able to deny the conviction on an application in the code, it goes further than just employment. It also applies to licenses and permits for government services and registration. So here we're talking about the Virginia DPOR, the Department of Professional Occupations and Regulations. So there, you're getting a license or a permit from anything from being a home inspector to HVAC, electricians, those sorts of things. So not only will they not see the conviction again on the application, you can deny it. And then being able to deny the prior conviction once it's sealed also applies to renting a home, purchasing a home. It also applies to insurance, and the code doesn't define insurance, it just says insurance. So you can see there's going to be a lot of ways that this is going to benefit people that have their convictions sealed. One thing I think for the business community to think about is that the code actually says that if you have an application for employment and you are asking whether or not the person has a prior conviction, you have to notify them of this law and say that if you have a conviction that has been sealed, you don't have to admit to it. one of the other things in the code is that it says that if you have a prior conviction that is a barrier crime and it has been sealed, it is no longer a barrier crime. A barrier crime is a lot of convictions that prevent people from working with children, the elderly, or disabled. So if you had a petty larceny conviction, you were 18, you could no longer work in these fields because of that conviction. Once it's sealed, you can now work in all of these fields. So what are some of the things that I think about for the business community and these laws? Well, there's studies that have been done and it's shown that $87 billion is the estimated cost to the economy of not including people with criminal records. And then get this, 82% of managers report that the value of second chance employees is as high or higher than people without criminal records. And I can tell you, I am talking to people on a daily basis that have criminal convictions. They want to work. There are people out there that I think are underemployed, and they are tired of, how the process works. You do the application, you think you have the job, and then the record check comes back and they say, hey, I wanted to hire you, but I can't hire you. These people are beaten down. I also think that people are actually underemployed. I talked to someone last week, and he's in collections, and he's like, look, I'm good at what I do. I'm great, but I can't work for a bank. I can't further my career. So I really think that there's kind of a waiting workforce out there. There's a number of people that can work at more competitive jobs, more challenging jobs, or just work at all. So also, on average, if somebody that has a record that is either sealed or expunged within the first year, their income increases by about 20%. The business community has actually, when the laws were studied, the Crime Commission said one of the problems in other states is just getting the information out about these laws. And unfortunately, there wasn't any money that was appropriated for publicizing these laws. Now we've got plenty of time, and it's more than a year off. So I'm sure people will become more aware of it. But you've seen in other states, the business communities have actually gotten together and promoted these laws. There's something called the Second Chance Business Coalition, and it has major corporations like JP Morgan, Target, Bank of America, Eli Lilly, Cisco, Allstate, Deloitte, and they are all promoting the fact that they are promoting these laws, the record sealing laws, the clean slate laws, but they're also promoting the fact that they are hiring people with criminal convictions. So I think, one of the biggest things that I would want folks to take away from this is just that I think that these laws are going to help employees, employers, but nobody knows about it yet. And so that's the challenge, is just getting this information out. So anything that anyone can do in the business community to get people to know about these laws, I think would be really helpful. This has been a very quick overview of what are some pretty detailed and sometimes technical laws. I'm happy to answer any other questions. I'm super easy to reach. The email is george@cleanslatevirginia.com. The website is cleanslatevirginia.com. There's a lot of explanations in the blogs about these laws, who it applies to, who it doesn't apply to. So, I'm happy to answer any other questions from folks about the laws.
Well, first off, how many were aware that this was coming up?
What do you mean?
I wasn't. Yeah. So
yeah.
Nobody in the room here has raised their hand that we were aware that this was coming. So, George, thank you for letting us know. So I'll start off the question with, I'm sure you guys have done research. What is the top crime or top charge that you see that was going to be able to be sealed and or expunged that will be able to help folks find employment? Is there a number one charge or number one category?
I think that it's going to be those lower level misdemeanor offenses. because there's, petty larcenies, things like that. Those are the types of offenses that when you're young, you get that conviction, you don't realize how it's going to impact the rest of your life for employment purposes, for housing purposes. And those are also the type of people that, really aren't necessarily going to reoffend. I mean, there's a lot of people that have a long criminal history, but there's a lot of people out there that have one misdemeanor, lower level offense. I'm hearing it every day. The state hasn't really studied the number of people because there wasn't a lot of value in it. The state hasn't studied the number of people that are going to be eligible. So we don't really know. All we know is that 4,000 people a year take advantage of expungement. And those are charges that were dismissed. I know it's going to be a lot more people that are eligible to have records sealed, whether it's automatically or by petition.
Other questions?
I suppose I have a question.
Oh,
So I was interested in hearing about that. I mean, I saw 1.6 million folks have a misdemeanor or an offense. I'm sure that number is broken down, and probably the vast number are misdemeanors, maybe one-time offenders, I would think. Is that an accurate statement, or do you have a breakdown of that number?
Yeah, I don't have a breakdown of that. I can just tell you anecdotally, I think that's accurate. Yes, I think that's true. I can also tell you too that one of the challenges with these laws across the other states is just getting people to take advantage of them. And one of the things is just a lack of awareness. Another thing is some of the barriers to actually having the record sealed. In Virginia, they recognize the value of having an attorney for the petitioning to seal. What they also did is they created an opportunity if somebody is indigent to apply for court-appointed counsel to assist the person in doing the petition to seal. So there's really an incentive for folks, even if they're indigent, to take advantage of this. And the funding for that is it's all self-funded. It comes from the fees the people are paying to have the conviction sealed. So that the legislature did recognize the value of having an attorney, but they also created an opportunity for folks to have a court-appointed counsel.
David, I think you had a question online. David, are you still with us?
Yeah, I'm here. I've got a question and a comment. I'll go with the comment first because it'll help with my question. I just hired somebody who, because we ask on our application, I guess 2 questions. Number one, are you still allowed to ask these questions on your application about, do you have any offenses? But number 2, I did hire somebody who admitted to having been in prison for more than a couple days, kind of a thing. But we went ahead and hired him anyway. So far, so good. It's turned out he fessed up to everything. It all matched the records we found. It wasn't a financial type of a crime. So the fact that there's, it's a retail business didn't bother me. But we had discussions about it, and we decided to give him a chance. And so far, it's working out great. So that's the positive side. That first question was, is it still going to be appropriate to ask those kind of questions on applications and of candidates? And secondly, are there any protections or insurance or anything that business would have available to it to make it more palatable for businesses to take that risk and chance?
First of all, David, I think what you're doing in hiring that person is awesome. It's great. And given my experience, I think you're going to find that that person is going to work as hard for you as any other employee you have, because he's probably hasn't been given the opportunity that you gave him. Now, as to the question about the applications, yes, you can still ask those questions. Absolutely. And some folks are going to have, it's going to show up that it's a felony that is not eligible to be sealed. And you're going to make the decision, I'm going to hire this person or not going to hire that person. So yes, you absolutely can still ask the questions. You can phrase it any way you want. You can phrase it, have you been charged? Have you been arrested? Have you been convicted? And you can say misdemeanors or felonies. The one caveat is that the law does require is that if you're going to ask that question on the application, you have to notify the person that if they had a conviction that was sealed, they don't have to admit to that conviction. So they don't have to admit to the arrest. They don't have to admit to the conviction. They don't have to admit to being arrested. And that applies also in employment. It also applies for insurance and applies for housing. Your last question about an insurance, the short answer is no. That was discussed in the legislation, and then nothing was actually done with that. So the answer to the question is no. There's no assurance. But there's no assurance in any employee that you hire. But I will say there are two programs. One is state, and I don't know a whole lot about these, but one is state and one is federal, that will actually bond people that have prior convictions. And what little I know about those programs is that they're very successful and they're well received by the business community and by folks that have prior convictions. So it's generally something that the employee would look into, is getting bonded. But as an employer, it's something to keep in mind that, maybe that could be your insurance right there, is have the person, hey, so go get bonded either through the state or this federal program, and then come back to me in a month and then let's talk again.
Okay. Yeah. Thank you for those answers.
George, that was an interesting point about the questions being whether you've been arrested or charged or convicted. Do you find that a lot of employers ask if you've been arrested? I think I've seen, have you been convicted quite a bit, but coming from a young man's standpoint, 25 years ago, if somebody would have asked me, had I been arrested, I would have had to probably say, yeah, I'd been arrested. And then, nothing ever came of it. But, that's never been a question that I've seen on an application. Convicted, yes, but arrested, is there more stringent applications you've seen that include that terminology?
Yeah, that's a good question. And actually, I see that less and less and less. It used to be more common when they would ask, employers would ask, have you been arrested? Because they were trying to cover all of their bases. But you're right, with the awareness of these types of laws and different things, the question of whether or not you've been arrested is much less frequent. I agree. One other thing that I'll note too is that in the legislation, because this was always kind of a gray area, like say you had a conviction or you had a charge that was dismissed, and then you also had it expunged. Well, if the question was, have you ever been arrested or have you ever been charged with an offense, even though it was expunged, you were still arrested or charged. So maybe you had to answer yes to that. It was tough to advise clients on that. Well, within the legislation, similar to how a conviction that is sealed, a charge that was expunged, you can also deny being arrested or being charged. So they kind of covered a little loophole or kind of a gray area for folks. But yeah, to your question, the question of whether or not you've been arrested, that's much less common these days. Employers tend to focus much more on convictions.